All right, we are back on the record. The record will reflect the presence of all jurors, all counsel, and the defendant are present. All right, Mr. Carlos, would you like to deliver your closing?
Yes, sir.
Whenever you're ready.
Good afternoon, ladies and gentlemen. Hope you all are a little bit more awake this afternoon, and this is the only time I'm going to get a chance to speak to you. The government gets to, the prosecution gets to go again because it's their burden of proof. So I just get this one chance, one opportunity to discuss this case with you, what it means to the defense, what is missing from the prosecution case, and how you should use the law. So it's important really to kind of put this in perspective, all right? And you really need to put this in perspective. We see cameras everywhere. You know, we see them on the outside. They're doing reporting on this. It's on the news. It's on the internet. But the only thing that matters, are you people right here, all right? You know, you've heard people say, you know, what makes America great? This is what makes America great. A jury of one's peers, 12 people selected from the community who have pledged an oath to be fair, to not attach labels to people, to apply the law, and to do the right thing. It's a difficult thing to do. Essentially, you hold this man's life in your hands, Mr. Winslow. And aside from a doctor, nobody really has that power, shall we say. Nobody has the ability to affect somebody's life like a jury does. That's why it's important when you're listening to the arguments, when you're going through the evidence, you realize your position. And your position is lifted, elevated from where we stand right now. You are looking down on the proceedings. What you have witnessed, what you have seen over the last 3 weeks, is exactly what you would expect in a criminal trial. You have seen a hardworking prosecutor and his team put their case together. He's done it honorably and with respect. You have watched a defense team do what we have to do in order to defend an individual. I mean, do I enjoy cross-examining people who are accusing my client of sexual crimes? Do you think I enjoy, sometimes being very, very aggressive to get to the truth? No, but that's my job. You wouldn't want it any other way. If you had a family member, if you had a friend who was accused of a crime, you would want exactly what we have done for Mr. Winslow. Because what we do is try to get to the truth. Prosecution presents their case, that's the truth that they believe to be. The defense gets to the truth through cross-examination. And that's what happened here over the past 3 weeks. So you saw both sides, prosecution, defense. You saw a judge who has ruled throughout this case, tried to keep things fair. And that's what he did from the bench. But now, we turn it over to you. And there's nobody, and I mean nobody, that can impact your decision but yourselves. And the only way to do this justly and fairly is to apply the law. And it starts with the presumption of innocence. Mr. Winslow is presumed innocent until proven guilty, all right? When you guys walked in here from voir dire, when we asked you questions, he sat here at this table. He was innocent until proven guilty. The first witness takes that stand, the second witness takes that stand, the third witness, to where we are right now. He is innocent until proven guilty. It's until you get back in the jury room and you discuss the case and you discuss the facts amongst all of you that you can make that determination. So when you're viewing the evidence that's been presented by the people, you need to view that evidence as if Mr. Winslow is innocent. Right? Not guilty, innocent. You have to make them prove it. This is not about him. This is not about who he is or what he represents. He is just like any other criminal defendant in this country. And he's just like any other citizen in this country. Anybody who's watching it on TV, anybody who's outside, anybody who's walking around. If they were accused of a crime, it would be the same standard of evidence, the same burden of proof. And we would hope that a jury would stand up and do the right thing and apply the law. That's how important it is. Now, understand what the prosecution is attempting to do in this case. While Mr. Owens was up here, I counted 21 times that he said there were 5 accusers. 21 times he said 5 accusers, 5 accusers, 5 accusers, 5 accusers, 5 accusers. Another 9 times he said this is a deviant. He's a sexual deviant. Think about what's happening here. You know, he also, I should mention also that he accepts that there are some major league holes in every single case that he has presented to you. He told you that. That's why he's telling you to put them all together. Because there's 5 accusers, 5 accusers, 5 accusers, 5 accusers, 5 accusers, sexual deviant. He wants you to forget about the holes. He wants you to forget about the lack of evidence, and he just wants you to take bits and pieces from each individual victim and make the other cases stronger. And that's not the way it goes. You will not get in the instruction packet is going to go back to you. You will not get anywhere an instruction that says where there's smoke, there's fire. You will not get that one. But what you will get is that each charge has to be proven beyond a reasonable doubt. Each and every charge. 3515. Each of the counts charged in this case is a separate crime. You must consider each count separately and return a separate verdict for each one. Do not fall into the trap of picking pieces of evidence and making another case stronger. It doesn't work that way. You have to be convinced beyond a reasonable doubt first that he's guilty of that crime. Jane Doe 1. Let's think about Jane Doe 1, right? First victim up. I want you to take this, when you think about Jane Doe 1 and all the witnesses in this case, I'm going to tell you how you have to view this evidence. Because we live in a country where somebody can point a finger at somebody and that is enough. Right? That's the good thing about our law. Yes, Mr. Owens is 100% right. Sometimes there's only one person. I got robbed. You robbed me. But still, there is evidence that's presented to support that particular finger point. And that's called circumstantial evidence. So when circumstantial evidence is presented to you, the law tells you how you should view that evidence and how you should apply it to the case. Cal Crim 224, the circumstantial evidence, sufficiency of evidence, tells you this, right? If you've got a piece of circumstantial evidence that's presented and it's subject to 2 reasonable interpretations, right? One that points toward innocence and one that points toward guilt. The law requires you to adopt the one that points toward innocence. It's in the instruction. You must accept the one that points toward innocence. This is not a suggestion. This is not, guidance where you say you might, you can if you think about it. Maybe you can. Well, if you feel like it, you can. No, you must adopt the one that points toward innocence. So each and every piece of circumstantial evidence, you have to apply the jury instruction, and you have to apply the law. Which means that if it's, once again, if it's reasonable, you can't say, well, that's reasonable, but he's probably guilty because of this. No! You are misusing the law. You also have to look at the witnesses. Cal Crim 226 tells you how you should look at the credibility of the witnesses, and that's what this case is. Credibility of witnesses. How well the witness could hear or otherwise perceive the things that they testified to. What was the witness's behavior while they were testifying? Were they combative? Were they honest? Were they influenced by something of like bias or prejudice? Maybe a motive, maybe a financial motive. Was the witness untruthful? Was the witness untruthful? So the law tells you that you should consider, particularly, somebody who is untruthful. And in this case, you have somebody who's not only untruthful, especially with Jane Doe 1, but is an admitted liar. All right. I want you to do this for a second. And I want you to imagine We're looking at Exhibit 114, which is a view of the parking lot and the freeway and the freeway on-ramp, right? And I want you to imagine for a second, this is a movie scenario, right? And it's a movie with no sound. And you come down, and now you can watch what's going on. And there's a woman up the road here, and she's sitting on the side of the road in white leather pants with her thumb out. Again, you can't hear the sound. Black vehicle pulls up. The woman goes to the passenger side. There's some pleasantries exchanged. You still can't hear what's going on. She gets into the vehicle. The vehicle drives down the road, pulls into a parking lot, passes many parked cars. Bank, grocery store, cleaners, fitness, goes all the way back to the back parking lot, right? Still, no sound. You see the man get out of the driver's side, walk around to the passenger side, and open the door for the woman. Again, no sound. You then see the man, you see these open doors. The man walks toward this field. The woman follows him. Right? Still no sound. The man climbs over the fence, starts to take his clothes off. The woman is on the other side of the fence. She's looking at him. She takes her backpack off, she throws it up over the fence, climbs over the fence, and now she's on the other side of the fence with the man. Still no sound. You can see them talking to each other. The man jumps back over the fence, back toward the parking lot. The woman takes her backpack, throws it back over the fence, climbs the fence, and now she's in the parking lot again. She follows the man behind him back to the car. The man opens up the passenger side, shuts the door. Then you see something happening inside the car. The woman's head goes down, and then a few minutes later, she is ejected from the car. The side door opens, passenger door is open, she's out on the street, this car starts driving away, and this person is chasing the car, screaming. Oh, I didn't mention, you're still watching this. As the car drives away, down and out in the parking lot, this woman, she just starts walking past all kinds of people and continues her day like nothing happened. So, like I told you, it's a movie with no sound. What does that look like? And what's it look like to you? You know, is a reasonable interpretation that there's some type of transaction that happened or some type of encounter, like a mutual encounter? Does it look like somebody got picked up and threatened and beat and raped? No, it doesn't. It's a reasonable interpretation of the facts, ladies and gentlemen. That is a completely reasonable. It's not even going anywhere near any type of imagination. So when you look at her story, she's hitchhiking. Now, think about this too. This is a woman who told you that she has only hitchhiked 5 times in her life. And the last time she remembers, she was 12 years old. So now, at the age of 55, when she's 1 block from her house, she decides she's going to hitchhike. And there's absolutely no reason for this at all. And, I mean, just to throw into the mix, her daughter says she's extremely paranoid. So what is an extremely paranoid person doing hitchhiking? For the first, since the last time she could remember, she was, 12 years old and something bad happened to her. She told you she was wearing the white leather pants on her way to the coast, highway, and downtown city is to quote-unquote cruise around, which is what she does. She got tired of walking after 1 block. She likes to walk, she says, but 1 block, and she decides to put her thumb out. In the parking lot, we heard testimony, we saw the photos. It's a crowded lot because it has these stores in it. It's got a Vons, it's got a bank, it's got 24-hour fitness, cleaners, sushi restaurant. All of that is there with a major parking lot by the freeway. This is not some excluded or some type of secluded location. This is in broad daylight in public. The photo that was Exhibit 23 that was shown to you in court really fairly inaccurately depicts it. You see the cars that are parked there. This is not an empty parking lot in the back. Cars parked there, people walk there. The doors to the sushi restaurant and the cleaners are visible in the photo. At no time did she ever even attempt to yell, to scream, to run, or even to walk away from the situation. The fence is important, really important here, because if you look at the fence and you see the prosecution during their examination, they tried to say, well, the ice plant is up, climbed up, and so it's not that big of a distance. But you heard her own testimony, and if we accept what she's saying is true, she used the brown marker there on the wall as the height. All right, that would be the second band of the brown marker there. With this top of the fence, which is, there's not a bar there. It's actually just exposed wire. And I suggest to you, ladies and gentlemen, it takes a lot to climb over that. I mean, it's not like something you hop over. It's something that you have to physically put your hands on, maneuver your body to get up and over this fence. So it takes effort. It takes the desire to get over the fence. Another telling thing is, she made sure to throw her valuables over the fence. She didn't want to leave them on one side of the fence. She put them over the other side of the fence and then followed them with her. And then once she was on the other side and they decided to go back, she threw them back the other way. Now what's important is, of course, she's told you, she testified, that the man who was going to rape her, the terrorist, was on the other side of the fence with his clothes off, and she was on the safety side of the fence within, you heard my investigator, 17 seconds, 22 seconds, 24 seconds, 26 seconds to safety. And that's, I don't want to disparage my investigator, but that's an older man walking. I mean, he's just walking. It could take, if you're moving, it's even quicker. If you turn around and yell, it's easier than that. If you take the phone out of your backpack and dial 911, regardless, there's a naked man on the other side of a fence. I'm sorry. They're gonna say we take our victims as we find them. Well, she's not. She's not a victim because clearly she's not frozen. She climbed a fence. She put her hands into a chain link fence and climbed over a fence. Took the care to throw her valuables over the fence and did it again. It's not a victim. The walk back to the car. She followed him back to the car. This man didn't pull her by the arm. The man didn't grab her by the scruff of the neck. She followed him. He even opened the door for her and she got in. She was within feet between distances, like I think she said in court, it was like from me to you, an open door. That's how far she was from an open door. You mean to tell me, really, seriously, that a woman who's climbed over a fence twice now, has driven by, multiple people in a parking lot, by multiple cars, is so frozen that she can't turn and walk 15 feet to a door? And don't tell me that, they would think that I'm kind of crazy and they wouldn't pay attention to me. You know what? Being crazy and attracting attention is one way to stay safe if you're being raped or about to be raped. Because you know what's going to happen? The police are going to show up. She didn't do any of that. Why? Let's think about that. Apply the circumstantial evidence, because all of this is circumstantial evidence. Why? Because she wasn't being raped, nor was she in fear for her life. Back to our movie. Inside the car, Jane Doe 1 told you that she leaned over to give him oral sex. She told you that he didn't grab her head. She told you that she didn't force anything. And she told Benavidez that the Officer Benavides, that the oral sex wasn't forced. The way she described it, think about it. She actually did it. She pulled up 2 minutes later, she said, on her own. I mean, she described the size of his penis. We all heard that. I mean, she was there. But clearly, it was an act that she was engaged in. She stopped doing it. You heard her testimony. She stopped giving the oral sex on her own accord and started to undo her pants and take them off. Now, the man inside did not force her to do this. She did it on her own. Once again, all of this is consistent. Every single piece of evidence here now is consistent with a consensual encounter. She then told you, said, bring it on. Get this done. Not help. If she can scream, bring it on, she can't scream help. She can't do anything. She sounds like a tough woman, right? You saw her testify. You're telling me for a second that she is frozen in fear. The man climbs over, according to her, the man climbs over the seat to have intercourse with her. And I suggest that might be a little difficult. Maybe it occurred somewhere else, if it did. But you saw the pictures of the Hummer. You know, Mr. Winslow, 6'4", about 245 pounds, with a woman there inside that front seat of the Hummer. Now, you heard Mr. Owen say that, you know, whether or not she was menstruating isn't such a big deal. It is a big deal. The reason it's a big deal is because what you have is a victim who is making things sound worse than they were. In other words, you make it look like this was a violent attack. If you were bleeding because you were viciously sexually attacked, that's different from you were menstruating. So the questioning about her menstruating is important for that reason, because it shows that she is willing to play hard and loose with the facts, so to speak. She will lie if she has to, but certainly it's not the result of her being assaulted. This is trial testimony. My question was, did you feel yourself bleeding? The answer was yes. And I have to ask you, but at this point, were you menstruating? No, I wasn't. Okay? This was this witness from this stand to you all. Said, no, I wasn't menstruating. In the same examination, just so we're clear, you're saying now that you weren't menstruating that day, right? She says, right. Okay, so the blood that you had that day was a result of some sort of trauma. She says, yes. She's telling you guys that. Okay, and I say, some tearing, literally? She says, right. And I say, you know your body. She says, yeah, it feels like my water bag broke or something, and it was like gushing. It was all red. It was just a lot. It felt like a lot of water, but it just gushed, like all of a sudden just swish, something like that. What's she doing? Right? She's claiming this blood is a result of her injury. But the reason we have cross-examination, you know, it's the ultimate truth-finding tool for, you know, people like myself who do this for a living. You find out a lot of things when you start asking the right questions. You know, once you start prodding people, when they're not questioned, you can say anything they want, but once they are under cross-examination, things change. During the same examination, I said, you were asked about menstruating. She says, yes. Do you recall what you said? You said, I guess I said I was on my period. We're referring to a previous testimony, previous preliminary hearing when she said she may have been menstruating. So back then under oath, let me ask you this. Do you recall saying, the question to her was, but now the truth is you were menstruating. She said, this was her answer. I guess, yes. I guess I was menstruating. No, I wasn't. I guess, yes. Okay, yes, I was. All right. Well, this is a completely unreliable witness saying anything she needs to say at any given time just to get on to the next question. And I say, do you remember saying that? She says, well, if I said it, I said it. I say, okay, do you remember saying that? Yes, which means that you really don't know whether you were or you're not menstruating. She says, yes, I was menstruating. I said, so the blood that we're talking about here from menstruating, here is from menstruating rather than being penetrated and assaulted. Is that correct? Yes, I guess so. So what you witness is essentially why cross-examination is so valuable. Because in front of you, right, in front of you, you can go back through the testimony and you can watch it all transpire. You know, a witness lied to you, the lie was exposed, and she admitted to it. And you have to question whether or not you can accept the credibility of this particular witness, of this particular accuser, when assessing the evidence against Mr. Winslow. So the evidence of the blood is still important because menstruation or not, there is no blood inside of the Hummer. Zero. If it was gushing, if it was spotting, if it was all over the place, like Jane Doe 1 said, there would be nothing, there's nothing there. You went over with a fine-tooth comb, and you can feel the prosecution start to panic when they say, oh, they had it cleaned, you know, it was detailed. You know, they showed you the nice fancy picture of them detailed. You know what they didn't show you? They didn't show you the fact that they didn't bother to even interview the detailer. This guy left. They see him do detail. They could have said, hey, let's stop him and find out what he's asked to do. Did Mr. Winslow come out to you and say, hey, you know what? You need to clean this seat here. There's a bunch of blood all over it. Or you need to use some extra cleaner over here because there's a bunch of blood on it. There's a bunch of DNA. You know, that might have been something helpful. They could have said, Mr. Winslow told me to go extra hard on some of these parts. But they didn't bother. They didn't bother to ask the question to the cleaners. And then they have the audacity to come in here and tell you that that is consciousness of his guilt. They're asking you to speculate. The same thing with the sale of the Hummer. They know who he sold it to. Did you see any interview with them? No, because they didn't. They want you to speculate. They are throwing things up for you to attach a guilty persona to Mr. Winslow. The mere fact that they can actually tell you to take those into consideration for consciousness of guilt, you should turn it right back and throw it back in their face because they did absolutely no investigation, none, zero, other than to observe it and then attach a meaning. So, you know, the sale of the Hummer, the cleaning of the Hummer mean nothing. These are 4 months after the event. He could have cleaned it at any given time if he was worried about having any type of evidence inside his Hummer. The last part of this, Jane Doe 1, the ejection from the car. You know, it's interesting what she said. Remember, cross-examination is a truth-finding tool. You know what she said about getting out of the car? She said, he just got mad. He just goes, just get the fuck out of my car. And he's just, you know, he was just mean. All right, I want you to think about that for a second. Somebody who's been raped, picked up, kidnapped, taken to a remote location, I guess brutally raped, what they're saying. She's saying the guy was mean? Really? When we go back to the circumstantial evidence, is that not the statement of somebody who's engaged in some type of, I guess, mutual encounter and upset that somebody just got mean? That's not what you call a rapist. You don't call your rapist mean. You call somebody that you had a contact with and they treated you the wrong way. Like, get the fuck out of my car. That might piss you off. That might get you upset. I guess he's being mean. So when you say get the fuck out of my car, does she get out and scream rape? You know, does she? No. I even asked her, remember, do you remember, were you making a scene? She goes, yeah, I screamed loud. You were able to make a scene, you were screaming things like, you pervert, you asshole. And she says, yes. So, once again, circumstantial evidence. One pointing toward innocence and one pointing toward guilt. Ladies and gentlemen, every single thing that she testified to, every single piece of circumstantial evidence to support her case points toward innocence. It points toward an encounter between her and the man that she was with, but not toward a rape. Because if she got ejected from the car, she'd be screaming and yelling down, following this car down the road, yelling, you know, police, 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 I've been hurt, I've been raped. But no, she's yelling, pervert, you asshole, you piece of shit. Those are the things she's yelling. And it's because he was mean and he kicked me out of the car. What did she do after this particular violent rape? You heard her, straight from the witness stand. I went about my day. Normal day. She told you that she walked around town, she talked to people, and this is the important part. She went down to the bus stop, the transit station, and the park. All right? The bus stop, transit station, and the park. Jane Doe 1 and Jane Doe 2 run in the same circles. You heard both of them say.
It's the evidence, facts not evidence.
Argument.
Just a moment. Overruled. You can cover it in rebuttal. You can continue, Mr. Carlos.
You heard their testimony. You heard from Jane Doe 1 that she walks to the bus stop, to the transit station, to the park. You heard her say that, yeah, I know a lot of the people from the streets, either by name or just because I know them from being around there. Same thing with Jane Doe 2, who hangs out at the bus stop, transit station, and the park. So she walks around in bloody pants for the rest of the day, apparently not traumatized and not really caring about her bloody pants, but just going about whatever day she had and not reporting anything to anybody, anywhere. You got a picture, you know, when I told you at the beginning here to have like a movie, you can picture her walking away, you know, after she gets kicked out of the car and she chases this vehicle, you know, toward the where the sushi restaurant is. She essentially had to walk through the entire parking lot. She had to walk. She told you she went back out to Santa Fe and then back down to the coast, which meant that she walked through this parking lot. Once again, some bombs. I don't know if you guys, I've never seen a bombs parking lot that isn't full. But this parking lot, tons of people. She took a left here, went by the banks, all the way to the street, walked all the way down to the coast, and then went about her day. Now, I agree with Mr. Owens that there really is no set profile for somebody, how they should react to rape or to being assaulted. But I don't think I'm being unreasonable by saying it's not this way. Clearly, the woman was not traumatized. Clearly, she was not raped. Everything about the encounter screams encounter and not rape. You know, and when you were listening to her testimony, you know I could see it in your eyes. I asked those questions from here, right next to the rail, to watch you all. And I watched you listen to the testimony. And there was some head shaking, there was some eye rolling, and that's well placed because that's exactly what was happening on the witness stand. She said some things on cross-examination also, which are troubling. One of the things she told us, I asked her, did you say that I put this man in a situation? Meaning that she put this man in a situation. And she says, yes, that's what I said. Now, is that something that a rape victim says? And she was essentially kidnapped and raped, but she's saying, I put him in a situation? She also told us, it's interesting, because I went through the trial testimony, and you can do this too. This is very interesting, that I asked her why would she get into the car if she's only hitchhiked 4 or 5 times in her life. Why would she get in the car? And you know what she said? She says, because he was a neighbor. Why would she say that? You know, we heard on direct that they were talking about him being from Oceanside. Why would you say because he's a neighbor? And I followed up. And she said that maybe someone told her at a meeting, I don't know if you remember that, I said, well, like an NA meeting, AA meeting. She said around the neighborhood or at the park. Right? So what she let slip out, was that she knows who he is. She knew where the vehicle came from. She knew this expensive vehicle. She didn't have to know that he's a football player. They just have to know that he has money. They have to know that you know, this particular vehicle costs a lot of money, and people are talking about it. You know, the prosecutors say, hey, there's no evidence that they filed any lawsuits or anything like that. That's, you know, we all know what can happen. You get a conviction, anybody can go to the lawyer and get they can file a lawsuit. There's no evidence of here. They're saying they didn't, they weren't asked whether that was the case. But they're certainly, this exchange here, when she told you that she didn't know who this person was, and all of a sudden said, well, he was a neighbor, that's why I got in, is very troubling. And it's there. It's in the testimony. Credibility is everything. And you have a woman who lied to you, who's clearly lied to you, and still wouldn't even admit that she lied about it. Your testimony is you never drank. She didn't say, I sometimes drink. She said, I never drank alcohol. Never drank alcohol. She swore to tell the truth, the whole truth, and nothing but the truth, and she did not do that in front of you. She follows up by saying, okay, not that I never drank alcohol, I was 30 years sober. Okay. Well, Jane Doe 1, what about these 6 arrests for being drunk in public? Well, I wasn't drunk. It was the cops. The cops harassed me. I drink a lot of cough syrup. I'm always sick. That's just a whole set of lies. Followed by, finally, when cross-examination finally beats her down to get to the truth, what did she say? And this is the truth. I didn't drink today. So she goes from this one here, from the witness stand in front of you, and went from never drank to I've been sober 30 years to I didn't drink today. You know, you can't put any faith in what she's telling you. There's nothing that corroborates her statement. There's nothing. Every single piece of circumstantial evidence supports this particular encounter that was mutual, and also you can't accept anything that she tells you to support her statement because she lies when she wants to. She lied about menstruating. She lied about alcohol. Who knows what else? But she's willing to do it, and she did it. Not only willing to do it, but she did it. You know, the interesting thing too is she said that she never talked to anybody about this until she went to the police. Well, we know that most likely is a lie if we believe her daughter, Summer, who said that she told her she was attacked. But if you remember, Jane Doe 1 said she never told anybody. She went to the police. The last thing I wanted to say about her, you know, and this is just has to do with credibility and the reasonableness of her story. The question to her was, she was asked during her preliminary hearing examination, she says, we're getting this image. He's like buck naked, as in he has no clothes on, all the way down. You have clothes on, and you decide to jump over the fence. Do you remember that? Is that exactly what you did? Yes. So I can leave you with that image. If there's not a reasonable doubt, I don't know what is. A naked man, a naked perpetrator, a naked rapist on the other side of the fence that is this high at the very least. Okay? And you are 15, 20 feet from freedom. That is completely unbelievable. Don't tell me somebody's frozen in fear. Don't tell me everybody, you know, doesn't act the same way. Don't tell me that she's a deer in the headlights, because she's not. It just didn't happen. She engaged in the conduct. Summer Foster. Come on, seriously. Summer Foster first of all, didn't know her mom was a victim, even though her mom said that, hey, we believe her. Her mom told her I was assaulted. But let's take that for granted. She didn't even know her mom was involved in this case. And she's watching this thing on court TV with the cameras and everything. Watched her mom give the testimony that you all saw, so we all know what that means. She watched the commentary from attorneys who talked about how unreliable she was and how much damage she was doing. That's the most important thing. How much damage she was doing in the prosecution case, the first witness out. And what does she do? She calls prosecutor. The prosecutors really jump all over this. They're saying, oh, great, this is going to help us. Did it really? You know? She came in here and said, oh, conveniently, I saw these pants and they had blood on them. Did we ever say that there wasn't any blood on any pants? I never attacked that. She conveniently said that her mom, this is important, her 55-year-old mom apparently can't use the computer and can't look up anything on SDTs and needs her help. That's completely unbelievable. Secondly, and more importantly, if you recall, she told you that her mom needed help in finding the sheriff's department, how to contact the sheriff's department. You recall that? Need help to get on the internet to find the sheriff so that she can make a report. And that is a lie. And do you know why? Question to Jane Doe 1. How was it you first contacted the sheriff's department? She said, I walked up there because I live right down the street. Did you ever call as you arrived? Call like what? Call before? No, I just walked up there because it's easier to do that. She lives right down the street. She lives walking distance from the sheriff. Summer Foster wants you to believe that she couldn't find the number or the contact information for the sheriff when they live right on the same street. So Summer Foster came in here to lie, and I can tell you what her motive is. That. She wanted $100,000. The one that's posted up there is $50,000. She posted this before she testified. She knew, and she's watching Court TV, that it's a national audience, that people might be glued to this particular case, that might feel sorry for her mom. So what does she want to do? I'll get $100,000 out of this thing. What's the motive on that? It's the oldest motive in the book. Pay me. You think she, $100,000, she'd get her mom therapy and relocation or whatever she wanted. At the end of the day, it's money. She knew full well that this was a national audience. It's not like any GoFundMe thing where you put it up there and hope people watch it. She would have a national audience. And what did she do after she testified? She went right outside and gave an interview to announce it. You are entitled to take that into account in determining the credibility of a witness. This witness is biased. She told you things that were just flat out lies about her mom not being able to contact the sheriffs. She told you that her mom was like guarded, and she was very, very, she had long-standing problems, and that's the reason she can't communicate well. She had no problem communicating to you. She had no problem lying to you. She had no problem telling you a story. So don't buy that. You know, that's a daughter. She probably loves her mother, but she's trying to help her out. She's trying to come in and help the prosecution case out because she believes something happened. Her mom knows different because all of her conduct was different. So Jane Doe 2, I told you, is in the same area. She's down at the bus stop. She's down at the train station. She's at the transit center. What's important to understand here is this is another case where there's no independent evidence of any assault. It's a woman who points a finger. That's it. So realistically, she could have said this happened anywhere. She could have said he drove her under a bridge. He took me to Tijuana. He took me to Oceanside. There's no evidence of it. There's no evidence of a car driving down the road. There's no poll cameras of a vehicle being seen anywhere. There's nothing to support this particular assault occurred anywhere, except for Jane Doe 2. The SART exams, which she gave the next day, revealed absolutely nothing. Zero. Go back and listen to the testimony. The important thing to remember about SART exams is this, or any medical exam for that matter. The patient history is what more or less controls it. So I tell you this is what happened, and then they look for something which might support it. But this SART nurse told you, the same nurse, told you that these are findings. They're not conclusions. All they are her observations. Now, whether or not they support what the patient is saying, you know, it's up to interpretation of something else. She can't tell you what they mean. She can only tell you that they're there. she also can't tell you when they got there, how long they've been there, or what caused them. So what do we really have at the end of the day? We have redness on somebody that she's never examined before, redness in the vagina and redness in the anal cavity, and she's never seen this woman before. She told you that they can be the result. I actually used the words that she used. They could be from consensual, non-consensual sex, or non-sex related activities. Okay, so basically that's everything. Consensual, non-consensual, or non-sex related activities. I can't think of anything else. So she's telling you that these are things that I saw, I can't tell you what they mean. But, there are things that you can, right? She told you that the patient indicated that she had sex 3 days before, consensual sex. And these particular findings are certainly consistent with consensual sex. The findings that she did see, which are actually visible, are none. No scratches. Whoops. Sorry. Yeah, no scratches, bruising, no vaginal tearing, no anal tearing, or anything that could support a violent assault. Now, here's where you got to check in with a little common sense. All right? It's easy for an expert or anybody in the prosecution saying, "Oh, 50% of the time there's no injuries." What does that mean? Like 50% of the time people go to jail for the wrong reason? No. You need not check your common sense here, ladies and gentlemen. Just think about it. I want you to think about it. This is a former NFL tight end, right? With enormous hands. He's a big man. This is not, a young, 150-pound man choking somebody, raping somebody. We know, at least from one witness, that he also has an incredibly large penis. We all laugh about that. But think about it, put that in context. The rape that this woman described, being thrown down in her seat, being vaginally penetrated, right? Held down, turned around, anally penetrated. She's not accepting these things. I mean, she's moving around. She has to squirm and stuff. Then this 245-pound NFL receiver with large hands grabs her by the throat and chokes her. She can't breathe. She can't talk. It's pushing against her voice box. She says it changed her voice. You really, for 2 minutes, you heard the Sartner saying, 10 seconds puts you unconscious, 1 minute you can die. Think about it. Do you really, for a second believe that there would be no marks? The first reaction, when the prosecutor was saying, what's your first reaction to in a choking situation? It's not what he said. Your first reaction is to grab the hands. Your first reaction is to dig your fingernails underneath those hands, to pull those hands off of your neck because you're dying, you can't breathe. The second reaction is to claw at the person who is strangling you. But nothing. There's nothing here. Zero. It's unsupported. All of her version of the assault is unsupported. The route of travel is unsupported. The previous relationship is completely unsupported by any facts or evidence. Think about it. This is a homeless woman who told you she has to get food off the street. She has food in a food bank or in a garbage can. She has no money. But Kevin offers her money and she says she never took it. She says she only rode with him one time before. One time. Right? You remember that. She rode with him the first time and then the night of the assault. That's what she told you from the witness stand. But Christina Garvey told you that Jane Doe 2 had indicated that they'd had coffee 6 times prior to her being taken advantage of. 6 times. That requires her getting into the vehicle and going somewhere for coffee, if what they're having is coffee. On the date that she got arrested, on the date that the assault, remember, she ran to this vehicle. She was happy to see the vehicle. You know, she rushed over there. She saw Kevin there in his vehicle. She said, "How you doing?" She went back to get her bag, right? And then she went back and got into the vehicle. She was so rushed that she left her phone with her friend. Clearly has been in the vehicle with him in the past. And she even told you from the witness stand that she told her friend that she was leaving to go for coffee with Kevin. And she's told you that was my suggestion. Not Kevin's suggestion, that was my suggestion to go for coffee. You know, if Mr. Winslow was this like crazy rapist, he had 6 other opportunities to rape this individual. If he is this groomer of victims, he had plenty of time to do this. What was it about this night that he couldn't control himself? What was it about this particular night that he said, "You know what, I'm tired of all this coffee drinking, I'm going to rape you"? What evidence do they have of that? They have nothing. They have just as much as Jane Doe II has about what happened. Most importantly, she never told the police about the discussion of sex for money in the past. That's important. And the reason it's important is because they asked her, why would he want even sex from you? I don't know. I have no idea. We never talked about it before. But it wasn't until the day before the prelim, when she knew that she was going to testify under oath, she knew that she would have to, raise her hand and she might get cross-examined by somebody. That's when she said, "Oh, by the way, I forgot to tell you. Yeah, he did ask for sex for money before. $40 or $50. There was some talk." So you got to wonder how much more there was. You got to wonder why she withheld that information. She also told Officer Moses the day after the event that the choking that she witnessed the choking that she had was not related to the sex rather than the event. So that's important also because she's looking at it in a different perspective, not as in a violent rape as much as just the same thing that she said about the accidental anal penetration. I mean, why would you say it was accidental if you're being raped? I mean, how does that pop into your mind that it's accidental that you have been anally penetrated? Same thing as the choking not being related to the sex, not the screaming. I mean, all of that is something that you need to consider. Likewise, the ride down Manchester and then the abrupt U-turn that she took. All right, I mean, let's get this out of the way. We all live here, right? This is not some foreign country. This is San Diego, California. It's not the country. This is not a deserted road. Manchester is a major road that goes to the Interstate 5. And it's not like it's 5 miles from the 5. It's within a half a mile of the 5. So it's not like this is some country road. We played this. Take a look at the road. Imagine, even at night, where's he going to park? He's going to flip a U-turn. We're going toward the freeway right now. Where is he going to park? Do you really think that there's no cars traveling on this road at any time? I mean, do you really believe that this is a deserted road? Absolutely not. He would have, according to Jane Doe II, would have had to flip this U-turn and then rape her, get out of his car, go to the passenger side, open the door to the Hummer, and you know what happens when you open a door to any new car? The dome light goes on. So the interior of the vehicle would have been lit up. It's this huge Hummer, and he's raping her on the side of the road where it would stand out like a sore thumb. Is that very realistic? No, it's not very realistic because it didn't happen. There's no evidence of it. There's nothing. There are no witnesses to it. This is all her version of events, which is unsupported by any type of evidence, just like that's the thing. You can support, and there's no evidence. Just like the neck. That's the killer. The most important part of Jane Doe is the neck, and the reason is her description of the choking ramps up the violence of the case, ramps up the violence of the attack, and we know that isn't the case because there are no marks. She claimed that she was choked for 2 minutes. You heard it from I said it before. There's no marks on here. Look at the pictures, right? Nothing. Zero. Nothing. This is the day after, not a week after. This is the day after. Are you telling me that a 240-pound football player with large hands, who has your hands around somebody's neck, who is choking you for 2 minutes, choking the life out of you to the point where you can't breathe and you can't speak, and there's not even one tiny little bruise? Zero. You have these pictures. You heard about the petechiae, which is an indicator of somebody being choked. Nothing. Zero. Don't tell me that 50% of people don't have any marks. Don't tell me that that's what you're going to hang your hat on, because this would leave marks. This particular event, holding somebody down, a larger, stronger man would have left something, and there is nothing here. And why is it important? Because of this. I asked her, did he put 2 hands in your throat? Her answer was it was 2 hands. And he knew he's smart because he did it in a way that he can't leave any marks. He did it in a way he can't leave any marks. I'll tell you why that's important. It's important because she looked at the photos. She saw the photos.
Objection, facts not in evidence, and this needs to be evidence.
Sustained.
She
I'm
knew.
going to ask for an admonishment to disregard the last comment.
All right, the jury will disregard the last comment, although, as I've told you before, what the attorneys say is not evidence. If anything they say contradicts what you find from the evidence, you go with what you find from the evidence as well. All right? Go ahead, Mr. Carlos.
How's this? She looked in a mirror, saw there were no marks. Okay? Sometime after she reported this thing, after she reported this strangulation, this choking by this man, she looked in the mirror and saw that she had no marks. Nothing. Zero. You didn't hear anything from any evidence tech about DNA found in her fingernails, from the scratching she did of this individual, about any bruising that was on her hands. Remember she said that this guy grabbed her by the hands and pushed her down? No bruising on the hands, no bruising on the fingers, no bruising on the legs, no bruising on the back, no bruising on any single part of her body. Nothing. Zero. No evidence whatsoever. So, ladies and gentlemen, let's be clear about this. The only evidence of any assault comes from her, and that's it. Don't be fooled to say there's some type of circumstantial evidence that they presented, which is credible, because there's nothing. In fact, everything points the opposite way. She's being less than honest with you about the choking, clearly, to make it sound worse. We know that she's talked to people, that she talked to her friends, and her friends know that this person drives this car. It doesn't take a rocket scientist to see where this is headed. You don't check your common sense at the door. You get to use it if you apply the law the right way. Jane Doe 3. At the beginning of the case, Mr. Watkins got up and told you about this particular case. And we said that we were going to show whether that at least Jane Doe 1 and Jane Doe 2 were related to a bias or a motive. And I think we've established that. Jane Doe 3, right, is something that essentially law enforcement put together. Because what we know is Jane Doe 3 didn't identify anybody. So the police showed her the picture. The police brought her in. The police are the ones, the prosecution are the ones who are putting her up there. And I'll go to Jane Doe 4, obviously had a reason to, she doesn't like Mr. Winslow at all. So she has a motive. And Jane Doe 5 is another created by the media because Mr. Winslow was all over the TV. I'm going to stay with Jane Doe 3 for right now. I want you to think about what Jane Doe 3 said. This is a woman who has seen this guy David and spoke to him on a previous occasion. See him, talk to him, look at him. That's what she saw. The second occasion, he spoke before he exposed himself. So once again, she got to see him. Police showed her a photo lineup. And she said none of the photos were the suspect. Right? Mr. Winslow was in that photo lineup. She came to a preliminary hearing and testified in court with Mr. Winslow sitting at a table. She couldn't identify him. She came to trial, right? Sat here, Mr. Winslow's right in front of her. She couldn't identify him. And you know what's really important about that? They didn't ask him to. Mr. Owens Could have said, hey, is that the guy over there? Because he knew what the answer would be. She'd say no. That's what she told everybody else. Why wouldn't he ask that? She identified the tattoos, blue, like the flag, right? Similar to the police officer in the body cam. He had some blue tattoo. She pointed, and I don't need a picture for this, but she pointed to that flag up there. So we all see what color blue she's talking about. You can look at Mr. Winslow's tattoos, and you can see there is not one piece of blue on there. There's a green, and there's an orange, and the rest are, like Mr. Watkins talked about, tattoo green, dark color, not blue. Can't even be confused with blue. The picture that is shown to you right there, the bottom part, is from the body cam of the officer when she was talking to Jane Doe 3 and talking about the color of her tattoos. He rolled his sleeve down. You have access to the video, you can watch it. But he showed this blue to her, and she said, you know, something like that. So we have the blue, the color of the flag, but clearly the blue, and not dark tattoo green. She also said that she described him as 5'8" to 5'9". Remember, she's seen this guy 2 times. And she used an officer as a guide to say how tall he was. And said the build of a cyclist, not a bodybuilder. There's a big difference between somebody who's a cyclist and somebody who's a bodybuilder. And so clearly, this individual is not the same person, but at least the individual who exposed himself is not Mr. Winslow. So they presented you with some Strava information, right? Shows the routes that Mr. Winslow may have taken, or at least his application took from a bike. And what it did is it put him in the vicinity the day before, the vicinity of the victim, Jane Doe 3. But there's no credible evidence that the route went into her driveway. They're saying, yeah, it's close to it. No one really says that this is where it went to. But it's important, though, on the day of the actual exposure, Mr. Winslow, if he was on his bike and that his Strava route, was going the opposite direction. It didn't go in there. Clearly, he wasn't even there, by their own evidence. So Jane Doe 3 didn't see anything, didn't identify Mr. Winslow. There's no evidence that puts him there. There's no evidence that, other than the prosecution is saying that it's him. She clearly can't say that it's him. Jane Doe 4. Now, Jane Doe 4 is, I don't even know how to start with Jane Doe 4. Jane Doe 4, something happened to her in high school. Clearly, she's upset with Mr. Winslow and has harbored a long-term resentment for Mr. Winslow. Because we know that she had, at least by her testimony, had consensual sex with him. And then Matt came in. She didn't like what happened. You know, she had a bad experience with him. Regardless of what experience she had, she waited 15 years to disclose this to the authorities. 15 years. And in between that time, just told, well, we'll get to Nikki, but her boyfriend Guillermo and then her husband later about an alleged assault. But what really tripped things up was she saw a Sports Illustrated article about this man, Mr. Winslow. And Mr. Winslow, who had everything. You know, I'll be honest with you too. You know, you heard it from the prosecutor too. He was a star. He was all pro. He was a professional football player. He had everything. And Jane Doe 4 knew that. But now he's being accused of rape. And she reads from Sports Illustrated that they may use CTE as a defense. That the defense may say it had something to do with, you know, his trauma to his brain as a result of playing football. But so Jane Doe 4 would have none of that. None of that. He's not getting away with this thing. There's no way he is. So she contacts her friend Nikki. Nikki, you remember? Do you remember? And then she didn't remember at first. You can read through these things. Didn't remember at first, but then, oh yeah. Prodding. So Jane Doe 4 says to herself, and she said it on the witness stand too, that she wanted to support the victims, right? Whether what they're saying is true or not, she didn't care. She wants to support the victims. So Jane Doe 4 inserts herself into the case. She decides she's going to call the police. I'm going to call them. I'm going to call law enforcement, and I am going to relate what happened to me. Right? Now, this is really, really, really important because the prosecution doesn't even want to address it. They didn't do it in their direct, and I challenge them to say something on the rebuttal about this because they know what it means. Because Jane Doe 4 had the opportunity to think about what she was going to say. She had 15 years to think about what she was going to say, and she picks up the phone and she calls the hotline from the article she was reading. A hotline that goes directly to the investigation of Kellen Winslow. Call goes in to the sheriff. It gets directed to Sergeant Emig. And Sergeant Emig is not just some guy sitting at a desk. He's not some guy like in a TV program that you see you saying, yeah, whatever. He is the supervisor of sex crimes. Supervisor of sex crimes. His job? To basically make sure the investigation of sex crimes is done correctly by his officers, to manage them. He has experience, he has training, he's written hundreds of reports, if not thousands in these years. So believe you me, when the call comes in, he's taking note of what they're saying. He's not just saying, oh, this is just some nutcase. So he's taking note of what this person is saying.
All right, Mr. Carlos, let me interrupt right now. I received a note that we need to take a courtesy break at this point. I hate to interrupt you at this point, but we do need to take a break. So we'll take a 15-minute break. We will see you back here in 15 minutes. Please remember the admonition. Don't discuss the case with anybody. We'll see you back here in 15 minutes.
Jury coming in. Please come to order. Court's in session.
All right, we are back on the record. The record will reflect the presence of all jurors, all counsel, and the defendant are present. Again, I was sorry to interrupt you, Mr. Carlos, but as I said, we had to take a break. And you can go ahead and continue.
Reset here, figure out where I was before. So Jane Doe 4's story is the first call that she makes is incredibly important because she's got 15 years to think about what she's going to say, and she's got 15 years of just anger toward Mr. Winslow, and so she's going back and forth with Nikki, and this is it. I'm going to do it. I'm going to be a part of this thing. I'm going to make that call. So she makes the call, gets routed to Sergeant Emick, right? So Sergeant Emick says, what happens? She has a 20-minute phone conversation. Now this is once again important to think about because Sergeant Emick said it was 20 minutes. Jane Doe 4 said it was 20 minutes. There's a lot to talk about in 20 minutes when you're taking a report of a sex crime. You heard on examination by the people, Mr. Owens asked Jane Doe 4, oh, did they tell you not to be specific? Did they tell you that you were going to be interviewed later? Seriously, that's a joke. She calls sex crimes. They say, this is Sergeant Emick, sex crimes, what happened? And she tells her story. It's not about being specific. She gave specifics. She told Sergeant Emick exactly what she believed happened. What did she say? She said she was picked up by Kellen Winslow in his SUV. She said Winslow gave her alcohol in the car. Winslow gave her alcohol in the car. She blacked out, apparently while in the vehicle, and awoke groggy. What did she wake up to? Winslow's friends digitally penetrating and fondling her breasts. Okay, now, we know that Sergeant Emick wouldn't lie and make these things up. We know that Sergeant Emick has really no dog in this show. We know that his job is to take down reports. So this is what she told them, which is completely different from what she testified to at the preliminary hearing and again in trial. And the significance of it is, this. It's like if there was only this story right here, if this is all we had, and you were to convict him based upon this story, then you would be 100% wrong. Because Nikki said this never, Jane Doe 4 said this never happened. But that's what she sold Sergeant Emick. And Sergeant Emick wrote it down. He wrote a report. Oh, by the way, she also, I should mention that she told Guillermo, her boyfriend, 6 months later, that this alleged assault with a person that she didn't name happened in a car. Not in a house, not in a place with stairs, in a car. So the version 2, she tells the investigators some 2 months later. She met Winslow at a party. She had 2 to 3 drinks. So this woman could be 2 drinks. Think about this. This woman, she's in high school. She knows how to drink. She normally drinks 2 or 3 beers. This is not anything new to her. She ended up at a house, and by the way, the drinks were not provided by Mr. Winslow. I asked her repeatedly, were you given anything by Mr. Winslow? No. Were you given anything by Matt? No. Were you given anything by anybody associated with Mr. Winslow? No. When you were at the house, were you given food? No. Were you given water? No. Nobody, and by the way, she took her own cup to the party, watched the beer being filled into her cup, which she drank. Nobody put anything in her drink at all. There's no opportunity for anybody to put anything in this drink, in her drink. She felt buzzed, but not drunk. That was her testimony. Felt buzzed, but not drunk, and then blacked out on the couch. I mean, that doesn't sound like something that happens very often. 2 to 3 drinks, you feel buzzed, and all of a sudden you pass out. That's it, no memory of it. She awakes to find Winslow penetrating from behind and then shoving her face into Matt's penis. She looked over to see 2 other people videotaping her. Right, so just look at these facts right here in comparison to what she initially told Sergeant Emick. They're entirely different, 100% different, other than Mr. Winslow being involved. Matt tells Kellen to stop. Kellen stops. Matt, one of the rapists, he helps her get her clothes on. Hey, are you okay? Do you feel like you've been raped? Hey, are you all right? He's the rapist, Matt. Matt picks her up and carries her downstairs. This is also important to remember. Carries her downstairs into the car, white BMW, drives to her friend, Nikki, who's standing next to Chris. Matt picks her up out of the car, carries her over to Nikki, puts her in the car, and they drive away. Right? That's a pretty significant fact, don't you think? Don't you think that if your friend is a victim of some gang rape, victim of some horrible event where you heard Jane Doe 4 talking about the fact that she was crying uncontrollably, don't you think you'd remember somebody carrying your best friend to your car? You know, and Nikki never did. She didn't remember any of that. What's the significance of the first call? Sergeant Emick wrote his report within an hour and 20 minutes. So it's fresh in his mind. There's no opportunity for him to be wrong about what she said. There's no opportunity to make things up. He wrote down what he heard. So the most important thing is not only does Jane Doe say that it was not true, she claims that she never said it. Okay? You gotta let that sink in. She's saying that what Sergeant Emick wrote down is not true. Okay? That's Sergeant Emick attributing to this phone call he got from her. And she's saying, not only is it not true, I didn't say it. Who are we going to believe on that? Because if we believe Jane Doe 4, that means that Sergeant Emick just made this whole thing up. Just decided to write a report which is entirely inaccurate based on statements that were never made to him. So how likely is that? It's not, because he has no reason to do that. Once again, he's a specialist. He's not just some guy at a desk. He is a specialist in sex crimes. And he's writing the report down. Jane Doe 4 tells us that not only is it not true, she never said it. So you have to reconcile that with her memory. You know, and she's telling you things that happened in detail from 15 years ago, which are conveniently broken up by a blackout from 2 beers. That's the level of evidence. There's no other evidence here, ladies and gentlemen. There's zero. They're just her word. You know, and the things that her and Nikki talk about after, you know, Nikki doesn't even remember half of it. She says, well, I think I remember we should have said something back then. Said something about what? You heard Nikki's testimony. Finally, think about this. Ask yourself, why did they call Emick? I mean, he's part of the investigation. That was, you know, they spent 3 weeks talking about this, like, you know, fresh complaint about how they talked to the boyfriend, you know, right 6 months after, and then 12 years later talked to the husband, you know, and then she talked to Nikki about it. They spent all that time talking about that, but they don't present the first law enforcement witness that she talked to. Why not? Why did we have to call him? because it hurts their case. It hurts the credibility of Jane Doe 4. It shows that she is inaccurate in her recall of details, because once again, she said not only did she not say those, but those facts aren't true. So what are you to do with that? You know, you got a man's life at stake here. You got somebody who's been accused of a crime, somebody is pointing a finger at you and said, you did this, 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 and this, and they give different versions of what he allegedly did. And not only that, she's saying that it never happened. The version 1 that I gave you never happened. Sorry. No harm, no foul. Don't worry about it. That's why they didn't call him. That's why the prosecution didn't call him, because it hurts their case. And it shows the weakness in the case. Nikki testified that she remembered none of this. She doesn't remember, the most simple thing, your best friend being carried to your car by somebody, crying, you know, it's a traumatic event. She didn't remember that. No delivery of a crying Nikki to Matt, by Matt. No incident where she was with Chris meeting up with Matt to pick up Jane Doe. In fact, all of her testimony is consistent with Jane Doe's version of the first consensual encounter. Remember, Nikki remembered a 2-story house. So did Jane Doe 1 on the first encounter. Nikki remembered she drove to the house. Nikki remembered there were a handful of people at the house, including Matt. Nikki was on the couch. This is the most important part. Nikki's on the couch when Jane Doe 4 comes down the stairs saying, we need to go. She's upset. If you remember, Jane Doe 4 said on the first consensual encounter, she was involved with them. She voluntarily had sex with them. She voluntarily involved in foreplay with them. Matt came in and they said, hey, can you watch? She was not good with it. She said, no, 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 that's not going to happen. Kellen stops. He doesn't rape her. He doesn't beat her. He says cake. In fact, he says, can I finish? And she says, no, 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 and so he stops. Jane Doe 4 told you she came down the stairs and she said she felt stupid, she felt upset, and she said, we gotta go. That's what Nikki remembers. Nikki doesn't remember anything about Jane Doe 4 being delivered to her, about Jane Doe 4 crying, about being in a car with her, you know, after Matt delivers it to her, none of that. She remembers the first incident vividly, and that's what she testified to. So there wasn't 2 incidents, ladies and gentlemen, there's 1. There's a consensual act take place between 2 teenagers, a 19-year-old and a 17-year-old. That is supported by Jane Doe 1's own testimony, by Nikki's testimony. Because we know Nikki was on the couch, we know that Jane Doe 4 came down the stairs, upset, telling her, we gotta go. I'm not cool with what they did. So nothing else supports this second event. There's no witnesses to it other than Jane Doe 4 and her memory. And how can we trust the accuracy of her details when she can call to make her initial report and give details that 1, she said she never gave, and 2, she said never happened. You know, the important thing too, Nikki does not remember anything about any boys going upstairs, because there had to be more than just Matt and Kellen. There were other 2 people that were filming. So Nikki didn't know anything about boys going upstairs where her best friend was. And the only allegations that she talked about that she described were that Kellen was so big. Nothing about this gang rape that happened, nothing about being videotaped, none of that. She does remember that Nikki said that that was not okay, and she's referring to that consensual first act, and the only one. She remembered Jane Doe 4 being annoyed and angry. Those were her words, annoyed and angry. That is more consistent with being in a room with a 19-year-old Kellen Winslow and his stupid friend Matt, who comes in and thinks it's funny, than it is with a gang rape. I mean, am I missing something here? I mean, applying the circumstantial evidence instruction, ladies and gentlemen, if one piece of circumstantial evidence subject to two reasonable interpretations, and 1 point toward innocence and 1 point toward guilt. Guess where this points? Toward innocence. They will jump up and down, and say it again when he gets up. 5 victims, 5 victims, 5 victims, 5 victims, 5 victims, over and over and over again until you just forget about why you're here. They will call him a predator. They will call him a deviant until you forget why you're here. But this is why you're here. The facts and the ability to recollect the facts by witnesses who have a reason to skew them. You know, I tell this to people all the time. You know, we don't know what goes on in people's heads. Every day we drive down the freeway, right? There are people driving by us, next to us, coming toward us, you know, in 2,000-pound steel death machines. We don't know who these people are. We don't know what they just did. We don't know what they're drinking. We don't know what their emotional state is, right? We just trust they follow the rules of the road. But the bottom line is that we don't know what goes on in people's mind. We don't know why they do what they do, and we don't know what their mental state is. We can try to guess. You know, we can look at them and say, well, you know, Jane Doe 1 just got some issues. You know, we can look at Jane Doe 4 and say, you know, you have to admit, at least you said something like this. But you won't, because she has adopted a memory. Whether it's true, that's why you're here. Regardless of whether it's true, she's adopted that memory. She will have that memory for the rest of her life. But whether it's true is something that you need to decide. And whether it's enough evidence to convict Mr. Winslow, it's only your decision. Jane Doe 4 will always have that memory. But we know that that memory is faulty. Her blackout, you know, come on, 2 beers, 3 beers. Very, very, very unlikely. The smallest of people, especially in high school. She had experience with drinking. She even knew what her limit was. She tried to keep it at 3, because she was stayed in control at 3. No person gave her food, water, drugs. And she only remembers arriving at the house and the sexual encounter. That's it. So it's kind of like this convenient blackout. Something that she may have adopted, something that, you know, it's really unexplainable that it's only that portion. You know, just a tiny portion of her blackout is just her being on the couch and then her getting upstairs. She also told you from the stand, I don't know if I blacked out. If I blacked it out, what she said. I don't know if I blacked it out. As in, I don't know whether I later blacked it out. Whether it actually happened or if I blacked it out. Those are her words. She also said, I don't know if I did something that might have escalated. Right? And she reacted to it now from the witness stand, but those were her words from the previous testimony. I don't know if it's anything I did that might have escalated it. So she doesn't really know what happened in general. We know that there was one incident that at least her friend Nikki can confirm. Nobody else can confirm any second incident. No one else can confirm this carrying of somebody individual to a car, or Matt, her rapist, helping. Nobody can confirm that. It's just Jane Doe 4's word. The only corroborating evidence is Nikki, who says all of her testimony corroborates the consensual activity that Jane Doe 4 testified to. Jane Doe 5, getting there. So you guys like numbers. Jane Doe 5, listen. She's a nice lady, right? Do I like cross-examining older ladies? No, I really don't. It's a difficult thing to do. And she fought with me, and she's feisty. I'll give you that. But like most people, like sometimes you stick to your guns. You think you saw something, and that's it. You know, somebody thinks they saw a UFO. Somebody thinks they see an alien. They'll stick to it. You know what I mean? That's their memory. But she didn't see anything. You know, she really didn't. If you listen to her testimony, she thinks she saw a lot of things, but she didn't see anything at all. She watched news reports about a football player accused of sex crimes. She told you from the witness stand that she didn't know that ahead of time. And we now know that's a little different. She clearly did. And Kellen Winslow, at the time, you've got a picture of Mr. Winslow at Crunch Fitness with an ankle monitor, right? Everybody knows who he is. Everybody knows who Kellen Winslow is, especially since that time he had been accused of a crime. So people knew exactly who he was. She says that she saw him touching his groin area and what she thought was an erect penis, right, on the exercise machine. All right, this is not a secluded area. This is not a hidden part of this health club. This is Crunch Fitness. You know, people come in at all hours. So Mr. Winslow decides, you know, on this particular day on a machine that he's going to stroke himself to the point of an erection in his sweats, I guess. You know, anybody can walk in at any time. She's moving to him, by the way. He's not moving to her. She's using the machines and gets right next to him, and then finally asks him to leave. Here's the important part, though. She said that the man walked downstairs to the main lobby with an erect penis. Right? Once again, how likely is that? How likely is it that the most recognizable guy at Crunch Fitness, the guy who's there a lot working out, the guy who's on trial for rape and out on bond for rape, subject of attention because he's charged with rape, how likely is it that he's going to walk down to that lobby? When you get back there, you can take a look at the exhibit. It's wide open. There's the front desk, right? No. He's going to walk down there with an erection, which Jane Doe 5 says conveniently he used his bag to cover it with. And I said, did you see that? Well, she goes, no, but he could have been using his bag to cover it. It's not very likely. This is, once again, doesn't fit any type of reasonable activity. I mean, you could get caught, you'd be seen. He's not making it down the stairs very far with an erection that somebody's not going to complain about it. The jacuzzi, once again, what did she see? Nothing. Zero. In fact, I don't care what prosecution gets back up here and says. She saw nothing because she told you, I don't want to look. She had in her mind, once again, this guy, the football player, the sick guy, now he's in the jacuzzi with me, I'm not looking. He's got this little towel around, she says a tiny towel around him that goes down above his knees, which is what everybody has at the health club because it goes down to the knees. And he gets into the jacuzzi. And this is where we get back to the circumstantial evidence instruction again, all right? So think about this. He sits down in the jacuzzi, in this jacuzzi, 5-6 person jacuzzi, he's sitting down. His arm makes contact with hers for like 1 second. That's what she said, 1 second, didn't hold on. So, that's circumstantial evidence right there. Is that a potential accidental contact, or is it a sexual contact? There's two reasonable interpretations for that, ladies and gentlemen. One is, hey, it was an accident. Two is, it's sexual in nature. But because it's reasonable if it was an accident, you have to adopt the one that points toward innocence. Likewise, the foot. Yeah, I mean, if you get into a health club, spa, and jacuzzi, and you make contact with somebody by accident, does that mean that you're trying to have sexual contact with them? No, it's an accident. Besides the fact, Mr. Winslow is a little large, takes up a lot of room. And even more telling than that, I think more telling than that, she couldn't see down the bubbles. This movement she talked about. What do people do in a spa? What do you rub? You rub a muscle, you rub an arm, you put it against a jet. She described his shoulder moving like this. Not a hand going like this, a shoulder. But she's automatically thinking that he's masturbating. There's nothing, she can't see it. She told you she can't see in the water. There's nothing at all to say that he was masturbating at all, zero. Just her assumption. Okay, last one of this one. He moves across to sit by the jets, and he says, ooh, this feels good. Right? You got one other person to help in the spa with you. You move to a jet and you put yourself against the jet and you say, ooh, this feels good. All right, circumstantial evidence, ladies and gentlemen. One points toward nefarious conduct, one points toward, hey, you know what? I'm sitting by a jet and it feels pretty good. You have to adopt, must, not can, not may, not I want to. You must adopt the one that points toward innocence because she didn't see anything. There wasn't anything there, and even worse than that, there was somebody else there. There was another man in the jacuzzi with Mr. Winslow in this exposed penis underneath the water masturbating himself. Do we have the complaint from that guy? Do you think that we might have heard something about it? Think about it. Did we? No. How likely is it? It's not. Remember, she testified here that she never knew Mr. Winslow was a football player, didn't know anything about him at all, right? So we, at the prosecution, brought on Officer Pacheco. Officer Pacheco, who did the initial report, who spoke to them. And what did she tell you? She said Jane Doe's husband stated, he's the football player, the guy with the problem, he's a tight end. Jane Doe's husband said, oh, I never said that. Why would Officer Pacheco lie about it? Why would she write it down? And she told you she puts them in quotes because that's what they said. The husband had seen him in the locker room before. Jane Doe admitted looking him up on the internet. That's what she told you. And the final thing she quoted was, this is a quote from Officer Pacheco, they brought it up to me. They knew who he was from the start. So how does that jive with the testimony? You know, it's a 79-year-old lady who thinks something happened to her, and her husband, who's in his 80s, who think something happened, and they're defending themselves. But the simple fact of the matter is what they told them before is they knew who this person was. I mean, he's on the TV. The people in the health club are talking about him. They know he's that guy, who's sick guy, who's charged with these sex crimes. And then all of a sudden, his wife thinks something happened to her. So the husband defends her. And then they're in the jacuzzi where nothing happens, and every nefarious intention is attached to Mr. Winslow inside the jacuzzi. But at the end of the day, zero. There's zero. There's nothing. There's no witnesses that were there at the Crunch Fitness complaining about Mr. Winslow exposing his penis to them. There's no man saying, hey, you know what? Going down to the supervisors downstairs and saying, hey, look, this guy's, you know, he's masturbating in the jacuzzi next to an old lady. No, they're not, because it didn't happen. It never happened. You know, Jane Doe saw what she wanted to see. She saw what she wanted to see. And that's in her mind. It's embedded in her mind. You know, memories are you know, as we get older too, they're a little harder to retain those memories. But we know that Officer Pacheco was there and wrote down the quotes and told you what she told them. All right. Those are the victims in the case, all the Jane Does. I explained to you, you know, how they came about. You know, how the Jane Doe 1 and Jane Doe 2 run in the same circle. They know people on the streets, people talk. You know, we saw that Jane Doe 1's daughter, you know, clearly came here to support her, but also has a financial motive in this, which is kind of shows you exactly, you know, that a lot of people could have financial motives. She's asking for $100,000 down to $50,000. You know, we talked about Jane Doe 4 and how she might be, you know, a little bit jaded about her memory. In fact, her memory is incorrect because we know that she told something completely different to Officer Emig. It's important that you remember that these cases need to be independently evaluated. You know, look, this is it. I'd love to stay up here for another hour. I mean, this is the thing we go through all the time. He gets one more shot, I don't. So I'm imploring somebody there who knows the way I'm thinking, so that when people say, well, there's like 5 together, I mean, where there's smoke, you can't have lightning 5 times. I want somebody to say, you know what? Every single case has to be done independently. That's what the law says. I need somebody to do that.
Overruled, you can cover it in rebuttal. Go ahead, Mr. Carlos.
You have to. You read the instruction I read to you at the beginning. Every single charge must be proven beyond a reasonable doubt. Pretty sure about that. Every single charge must be proved beyond a reasonable doubt. You get that through your head. Every single charge beyond a reasonable doubt. Don't take strong parts of one case to fill in the gaps for weak. That's not the right way to do it. You've got to apply the presumption of innocence, right? That's the important part, the presumption of innocence. And you know, I go through this a lot, and you know, it's cocktail party talk, presumption of innocence. Well, he's presumed innocent, so proven guilty, everybody knows that. But it's not until you have to apply it, you know? When you have to apply it in a very, very difficult situation like we have here, you know, today, that's when it really counts. When you have to apply it to somebody and have it mean something, that's when it really counts. So the issue then becomes, you know, what breaks that presumption of innocence? You know, it's the reasonable doubt standard. You know, and I started this argument by telling you that, you know, this is what makes America great is this. And our system of justice is what makes America great, because the burden of proof is a serious burden of proof. Mr. Owens accepts that burden. He'll tell you that it is a serious burden. It's beyond reasonable doubt, right? And the instruction tells you an abiding conviction to the truth of the charge. Abiding, right? And abiding means you can live with it. That's where the word root comes from. Abiding, abiding, abiding. Something that you can sit there a year from now, or, you know, 5 years from now, you know, say that this was the right decision. I always tell people that, like, a trial is like you walk into a bar, right? And you sit down next to somebody and you start telling this story. Tell a story about how you sat on this jury, covered by TV all over the place, involved this football player. We listened to this evidence from these 5 people that came in, and they told these stories. And we came to this decision. And you tell, you know, the facts of the case to this individual. And then they start asking you questions. You know, they're saying, wait a minute. Wait. So, you know, you get this right. The lady was on one side of the fence, and she jumped over the fence, and then jumped back over the fence, and followed him to the car. And they'll say, like, wait. Are you saying that she told the police officer that, you know, an entirely different event happened, and then 2 months later told a different story, and said that the first story never existed, or she never said it? Or you saying this lady said that she saw him masturbating, but then told you that she couldn't look under the water? You know, those types of things are what's called reasonable doubt, because you'd be sitting there telling that story and you can't explain them. I can tell you right now, because I've seen it in your eyes during this trial, that there are some things which are perplexing to you. Those are the doubts that have to be resolved before you can reach a conclusion in this case. You know, there are plenty of doubts. You know, these individual cases are like little boats, and these boats have holes in them, and they are in the water, and they are sinking. The prosecution wants you to fill those holes with the other cases. But there are some serious issues, and those are the issues that you need to deal with. Those are the issues that you need to be able to tell me, or tell anybody, that you sat on that jury, you've listened to the evidence, you came to this conclusion, it's the right conclusion. But, you know, I mean, don't tell me that somebody sitting on the other side of a 5-foot fence with a naked man on the other side and not running away, but instead crawling over a fence to go to that person and then crawling back over the fence to be assaulted. Don't tell me that's not a reasonable doubt. Don't tell me that a woman who claims that she was choked and raped brutally, for 2 minutes she was choked, and doesn't leave a mark, and then volunteers to you that he did it in a way that wouldn't leave marks. Don't tell me that's not a reasonable doubt. Don't tell me that a woman who cannot identify a person in a lineup, can't identify a person in court on 2 different occasions, describes something completely different from the individual in front of you. An entirely different man with entirely different tattoos. Don't tell me that's not a reasonable doubt. Don't tell me a woman who 15 years later tells a story to an officer and then retracts the entire thing. And not only that, says, I never said it. Having to rely on her entire testimony to convict them. Don't tell me that's not a reasonable doubt. And finally, don't tell me that a woman who hasn't seen anything in the jacuzzi, hasn't seen an exposed penis, has never met this man before, but knows that he's been accused of some very serious crimes and overreacts. She tells you that there's some type of masturbation underwater, but you can't see it. She don't tell me that's not a reasonable doubt. I mean, it's clear. Sometimes it's not a popular thing to do, but it's clear. Once again, you are the only ones that matter. You are the gatekeepers of justice, all of you, not us. We do what we do, but at the end of the day, it is you, 12 of you, who made that decision. You know, all I ask, you know, on behalf of Mr. Watkins, Ms. Barr, my client, and even Mr. Owens, and John Johnson, we appreciate the fact that you have taken the time, that you have listened to everything that we have had to say, that you paid attention. You know, it's been rough and, you know, sometimes a little bit hard, but, you know, we appreciate it. I am sure, I'm positive, that if you apply the law the right way, listen to what I've said, that you can come to the only reasonable conclusion, and that is that Kellen Winslow is not guilty of the charges that have been levied against him. There clearly is insufficient evidence to convince anybody beyond a reasonable doubt, unless you just say he is a deviant. Forget about it. 5, 5, 5, 5, 5, 5, 5, 5, 5, 5, 5 victims, deviant. Deviant, 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 deviant. Forget about the law. Do the right things, ladies and gentlemen. I know that you will. I've been watching you, and I know it's going to be a difficult decision for you, but in the end, there's only one clear thing that you need to do in this case, and that's a verdict of not guilty. Thank you.
All right, thank you, Mr. Carlos. We can start with rebuttals. Does anybody need to take a break at this time? If so, raise your hand. Nope? All right. Mr. Owens, you can go ahead and give your rebuttal argument whenever you're ready.
Thank you, Your Honor. Can I just have a moment, Your Honor?
Of course.
Ladies and gentlemen, it's nice to see that Mr. Carlos and I do agree on some things. Mr. Winslow is presumed innocent to start. Mr. Winslow is presumed innocent as he sits there right now. Mr. Winslow is presumed innocent unless and until you 12, based upon the quality and the quantity of the evidence in this case, join together and find him guilty. And this is the moment that we trust you with that decision. That the public, the community, trusts you with that decision. And it is the people's position, undoubtedly, based upon not just the number of women that came forward, but based on what they actually said, what they've actually testified to here in court, that shows his guilt. This case has been proven beyond a reasonable doubt. And make no mistake that this defendant bears a propensity, a predisposition to commit the crimes that he's been charged with. That's what the law recognizes, and that's what the law requires you to consider. If you find beyond a reasonable doubt that he committed one of these enumerated offenses that we've talked about, then you can use that evidence to prove that he committed the others. And make no mistake, Mr. Carlos will stand here and he will attempt to chip away at extraneous fact after extraneous fact, things that don't go to the core of what actually happened, and try to convince you or persuade you that this case hasn't been proven. But ladies and gentlemen, don't let him pull the wool over your eyes. Kellen Winslow is a wolf in sheep's clothing. He has the name, he has the money, he has the fame. But who does he choose to victimize? Women who are unlikely to report, who are vulnerable out on the streets, who are unlikely to be believed if they come forward. That's what he did last spring. And now you, as members of the community with your own life experience, come in and you have to listen to what they have to say and make a decision. What was glaringly absent from Mr. Carlos's argument? He doesn't want to focus on what Mr. Winslow actually did, about what the testimony was of his actions, his threats to kill them, when he forcibly raped them. No, he's talking about other things. The confusion, the beating them down on cross-examination, the ultimate admission to, well, maybe I was menstruating, right? Is that a lie that then impacts her credibility to such an extent that you can't believe her, Jane Doe number one, when she says what he made her do? What does he do when he sets up his argument? He says, all right, bird's eye view, aerial camera. You're watching this happen. It's a movie with no sound. Set aside what actually happened and look at it through this prism of doubt. Now, what Mr. Carlos did is he's attempting to misapply the actual jury instructions. He keeps arguing from the very outset that this is all circumstantial evidence, that there are two reasonable conclusions from this. But that's not what the law says, and that's not what the judge instructed you on yesterday. There are two forms of evidence: direct evidence and circumstantial evidence. Direct evidence is the testimony of the witnesses. That can prove any fact. When a woman stands here and says that I did not consent to the sexual acts that he forced on me, that when he threatened to kill me, I was fearful, and that's why he did what he did, that is direct evidence of his guilt. There is no reasonable inference to be drawn other than whether or not that's true. He is attempting to get you to believe that the law somehow requires you to find him innocent based upon direct evidence. And that's not what the law says. Circumstantial evidence is the type of testimony or the type of evidence that comes forward that allows you to infer the truth of what's being said. And ladies and gentlemen, when you do have woman after woman after woman coming in and testifying to those core true facts of what he had done to her, to each one of them, that is the circumstantial evidence that confirms and corroborates what the others have said. There is nothing in the law that requires you to put each individual case in its own separate silo. Put it over in this box and then consider it separately from this box or this box and this box and this box. Because why?
Just a minute, what's the objection? Overruled, I'll let him finish, go ahead.
Thank you, Your Honor. Because why else would you be the jurors sitting here listening to all of the evidence? All of the evidence that came forward in this trial can be considered by you in determining his guilt for each one of these 12 charged crimes. And don't believe him when he says it, that you got to separate it all out. Yes, this case must be proven beyond a reasonable doubt for each individual charge for you to convict him. Certainly. But in terms of your consideration of the evidence, do not lose sight of the forest through the trees. That's what he wants you to do. Well, if you focus on this tree here or that tree there, then you're not going to see the big picture. Reject that. That's unreasonable. That's the exact unreasonable defense theory that I was warning you of. And that's what he's trying to get you to buy. Don't do it. So Jane Doe number 5 must have been mistaken. She didn't see what she saw, and he didn't say to her what he said to her, right? Was she mistaken when she heard him say the words, "Do you see this? Do you like that?" Was she mistaken when she saw his penis erect, protruding from his pants? This was all just a big mistake? You heard from Jane Doe number 5, who explained when it was that she and her husband found out who he was. It's when Brad Moser talked to her about it, right? That was before Officer Pacheco was there. And Officer Pacheco took down her report and included in quotes that, yeah, at that point when they were talking to her, they knew that he was a football player, a tight end, right? But they told you from the witness stand when it was that they learned that. That, yeah, they had seen a prior news report months past, as she said, but that was in the back recesses of her mind. When he did what he did to her in the Crunch Fitness, she didn't recall that. She didn't recognize him. Was she lying? Was she being dishonest? Was that not an authentic, believable response when she was testifying? I didn't know who he was until after. And yet now Mr. Carlos is trying to say that Officer Pacheco, talking to her the following night, said, well, they knew it from the start. That is her inference based upon a report that she wrote down while working 4 p.m. to 4 a.m. and being asked to take a report from these people. Sergeant Emick, Jane Doe number 4. What's the actual evidence of how that statement was documented? Make no mistake about it. Sergeant Emick is experienced. Sergeant Emick does supervise within the Major Crimes Division, one of the units being the Sexual Assault Unit. He was not directly involved in the investigations, as he said. His detectives were directly involved in the investigations. That a protocol had been set up so that he would screen incoming calls and would provide the information for the district attorney investigators to follow up on it. Ladies and gentlemen, he took a phone report, unrecorded, no notes, as he testified. He sat there and said, nope, no notes. He called me to let me know that there was an additional victim coming forward. I asked him to document it. This is what he testified to. You recall it, it was just last Thursday. And an hour and a half later, after he had taken the information, he writes an email. After he writes an email, a report's requested, and he writes that 2 months later. Ladies and gentlemen, taking a phone report from a victim of a sex assault, whether it was the day it happened or 15 years before, 15 years after it happened, that's a difficult thing to do when they're in a traumatic state. What do we actually have documented and recorded? A lengthy 3-hour interview where we sat down with her in her own home, listening to all the facts and details that she could recall, and then the testimony that she's been able to provide based on her clear recollection of the events. Now, Sergeant Emick did what he could in order to try to accurately recall what was said in the conversation. But ladies and gentlemen, it's clear that he was misinterpreting what she said. There was a car ride, there were multiple people present, Mr. Winslow was raping her, and that she had drank that night. All of those facts are the same. Whether Sergeant Emick was able to accurately reflect what was said to him in that phone conversation does not create reasonable doubt. Jane Doe number 4's compelling, honest, authentic testimony before you proves his guilt beyond a reasonable doubt. And when Nicole Edwards is trying to recall 15 years prior what she was present for, what she recalled, she does misremember which night this happened. She does recall being in a house when Mr. Winslow was there. She does recall Jane Doe number 4 coming down upset. She does recall Jane Doe number 4 telling her that she had been assaulted. She does recall a drive in a car where Jane Doe number 4 was crying, she was upset, she was distraught. Who's the person who's going to remember the details? The rape victim. Who's going to know what actually happened on the 2 interactions she had with this man? Not her friend who's being asked about it 16 years later. Her. Was she lying to you based on some motive? Based on some incentive to try to really get this guy that she hadn't had any interaction with for the last 15 years? That's unreasonable, and you can reject that argument. Mr. Carlos is attempting to get you to look at every single individual case and any small inconsistency and create reasonable doubt, when in reality, everything is corroborated through the core facts of what each woman has testified to. Mr. Carlos claims that Jane Doe number 3 is a law enforcement creation of what happened, that it couldn't have been Mr. Winslow. And he gives short shrift to the way that we've actually proven that he was there. He says that there's nothing to suggest that he was in her driveway the day before the indecent exposure incident. You saw the GPS data. And then you saw where his route started the following day, when he clicked record on that Strava application on his phone and rode away from the scene of the crime. You also saw that this is what he would do regularly. He would be riding his bicycle in that area. He committed this crime, make no mistake. If it's an identity case, that's easy. You can find him guilty of that. Jane Doe number 2, what did the Strava application show you? You have Mr. Sesma taking a short 1-minute ride down Manchester on a Wednesday afternoon at 1:30, beginning at the community college and ending at a red light on the northbound on-ramp to the 5 freeway. Cars passing by as he does so. What does the Strava application show that Mr. Winslow did 3 days before he took Jane Doe number 2 on Mother's Day down Manchester Road to a dirt shoulder with no lights around? He rode all the way down Manchester along that route that Mr. Sesma took, but continued on past the 5 freeway to that area near the San Elijo Lagoon Preserve. As you heard the testimony from Mr. Sesma, there are no street lights out there. And as you can see from the maps that have been introduced into evidence, Mr. Winslow was familiar with that area. He knew where to take her. And he did. If Jane Doe number 2 was making up this rape, why didn't she say it happened under a bridge? Why didn't she say it happened out in Ramona? It happened there, on Manchester and Encinitas, just like she said it did. And you've heard no evidence whatsoever that she consented to the acts. Notice the gloss over that fact. The absence of evidence presented by the defense to show that she consented should immediately cause you to be suspect of the way he's argued that case.
All right, just know, the court's going to interpose its own objection. The jury will disregard the last comment by Mr. Owens. That portion of his argument will be stricken from the record. All right, you can go ahead, Mr. Owens.
Thank you, Harm. Ladies and gentlemen, Jane Doe number 2 has come forward. She was consistent when she was interviewed by Deputy Latonio, Detective Moses, Ann Williams, Detective Johnson, when she testified at the preliminary hearing, and when she testified before all of you. Not once has she ever even implied that this was in any way anything but a non-consensual rape. During the cross-examination of Jane Doe number 2, there was nothing presented by defense counsel that could lead you to make a reasonable inference that this was consensual.
Say objection, Your Honor.
Overruled. He's commenting on the cross-examination of Jane Doe number 2. That is proper argument and will be allowed. You can continue, Mr. Owens.
Thank you, Your Honor. Ladies and gentlemen, this was not consensual. Jane Doe number 1 was beaten down by Mr. Carlos. He just acknowledged it. He said that he doesn't take pleasure in doing it, and yet he laughs at her when he talks about what she said. When she ended up being walked down that road where she started to contradict herself, yes, that's skillful cross-examination, but it's an unsophisticated victim. We do take them as they are. You take them as they are. And you have to listen to the core facts of what's being said, what's being testified to. And what is it that he focused on? He focused on exactly what I told you people. The peripheral facts, the extraneous facts. Menstruation or not. Alcoholism or not. Ladies and gentlemen, never, not once, did she say that he didn't threaten her. There's zero evidence whatsoever that there was any sort of, quote, transaction. That's based on speculation, implication, and innuendo by an attorney representing a criminal defendant. There's no actual evidence of that whatsoever from any one of the witnesses who have testified. You can reject it as unreasonable. Now, in terms of your decision now, your consideration of all of the evidence that's been presented to you, when you look at the totality of the testimony, when you think about how it is that this case has come to be, how it's been brought before you, and what was actually said from the witness stand, there is no doubt that this defendant bears a sexual predisposition to commit the crimes that he's been charged of. He criticizes me for using labels. What else is it other than sexual deviancy? What else is it other than a sexually violent predator who's preying upon the perfect women? People that society has ignored, a drunk teenager who's kept a secret for 15 years, a homeless woman who lives at the transit center, a woman who has very little, almost no family support, save for her daughter coming forward, a woman who's battled alcoholism her entire life, as she told you, and a woman who was raped by this man against her will. Jane Doe number 3 and Jane Doe number 5 prove that he is a sexually deviant individual. All of it, when you look at it in sum, proves that he is what I've said he is. And all of it proves that he committed these crimes. You do have the power and the privilege to hold Mr. Winslow accountable for what he's done. You have a responsibility to look at the evidence carefully and discuss it amongst yourselves to ensure that every single one of you agrees that he's committed each one of these crimes. But follow the law, ladies and gentlemen, not the argument of counsel. I'm confident that each one of you will get together, discuss this, deliberate, and render a true and just verdict. There is only one reasonable conclusion here. This defendant is guilty of all 12 counts. Come together in one voice and find him guilty. Thank you.
All right, thank you, Mr. Owens. Can you take down the PowerPoint slide as well? All right, thank you. All right, Ladies and gentlemen of the jury, when you go to the jury room, the first thing you should do is select a foreperson. The foreperson should see to it that your discussions are carried out in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide the case for yourself, but only after you discuss the evidence with the other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors happen to disagree with you. Please keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please treat one another courteously, I'm sure you will. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. Now, as I told you at the very beginning of the trial, do not talk about the case or about any of the people or any subject involved in it with anyone, including but not limited to your spouse or other family or friends, spiritual leaders or advisors, or therapists. If you happen to be seeing a therapist, you cannot talk to your therapist about this case. You must discuss the case only in the jury room and only when all the jurors are present. So some of you might get friendly and want to go out for lunch with each other during the course of deliberations, but while you're at lunch, if it's just one or a couple of you that get together, you cannot discuss the case unless all 12 of you are present and in the jury room. Do not discuss your deliberations with anyone. Do not communicate using any form of electronic communication or social media during your communication or during your deliberations. You can't send out any tweets from the jury room or post anything on Facebook or any other form of social media. It is very important that you not use the internet, a dictionary, or any other outside resource in any way in connection with the case during your deliberations. During the trial, several items were marked and entered into evidence. You will receive those exhibits back in the jury room. There's also a DVD of the body cam video. We're going to send that back to you. We will also send you a clean laptop back into the jury room. This laptop has no files on it. I imagine at least one of you knows how to put a DVD in a computer and get it to play. If you can't, you let Manny know and we'll get somebody in there and fire it up for you as well. The exhibits will be sent back into the jury room shortly after you arrive there. If you need to communicate with me while you're deliberating, please send a note through the bailiff signed by the foreperson or by one or more members of the jury. To have a complete record of the trial, it's important that you not communicate with me except by written note. If you have any questions, the procedure I will follow is as follows. You send a note out if you have any questions. I will then come up with a proposed response. I'll have the clerk call each counsel and see if they agree with the response. If they agree with the response will go back into the jury room right away. If one counsel or both counsel object to the response, we have to reconvene everybody back here in court, go on the record with the court reporter, and put on a record the appropriate response. That takes time. So if you send a note out and I don't get back to you immediately, I don't want you to think that I'm ignoring you, because when I have a jury that's out deliberating, you are my absolute top priority, and I will get back to you as quickly as possible. You should continue your deliberations while you wait for my answer, and I will give you either a written answer or instruct you orally here in open court. Do not reveal to me or anyone else how the vote stands on the question of guilt or any other issues in the case unless I ask you to do so. So if you happen to send a note out, there can't be any numbers on it as to how you stand on a vote. In other words, you can't say our last vote was 8-4 for guilty or 8-4 for not guilty, and here's our question. I can't have any discussion whatsoever of how your vote stands. Your verdict on each count and each special finding or allegation that attaches to each count must be unanimous. That means in order to return a verdict, all of you must agree to it. Now I pause now because I'm required under California law to inform you of this, and I must instruct you on this portion of the law. I don't think any of you would do this at all because I know you all take this case very seriously, but I must instruct you that you cannot reach a decision by the flip of a coin or any other similar act. I'm required to tell you that, and I know that all of you understand the very serious nature of this case and would never even consider doing that, but I'm required to instruct you on that. It is not my role to tell you what your verdict should be. Do not take anything I said or did during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. And finally, you must reach your verdict without any consideration whatsoever of punishment. When you go back into the jury room, you're going to get the verdict forms. We're going to send those back in a couple of minutes. As soon as all the jurors have agreed on the verdict, the foreperson must date and sign the appropriate verdict forms and notify the bailiff. If you are able to reach an unanimous decision on only one or some of the charges, fill in the verdict forms for those charges alone. And if you're unable to reach a verdict on some of the counts, you have to leave those verdict forms blank, and you return any unsigned verdict forms to the court. All right, at this point, I will ask the clerk to please swear the bailiffs.
Each of you do solemnly swear that you will keep this jury together in some quiet and convenient place, that you will permit no person to speak with them or communicate with them, nor will you speak with them yourself about this cause, unless by order of the court, or to ask them if they have agreed upon a verdict, and you will return them into court when they have so agreed or when so ordered, so help you God?
I will.
Thank you.
All right, I'm going to ask the 12 jurors to pack up your personal belongings and your notebooks. I'm going to ask the 3 alternates just to remain behind briefly. And you can follow Manny back into the jury room. Take this.
Yeah, of course.
All right, the 12 jurors have now left the courtroom. To the 3 remaining alternates, as you can tell, the jury's on its way out now to begin deliberations, but the 3 of you are still alternate jurors, and you were all 3 still bound by my earlier instructions about your conduct. Do not talk about the case or about any of the people or any subject involved in it with anyone, not even your family or friends, and you can't even talk to each other about it, okay? Do not have any contact with the deliberating jurors. Do not decide how you would vote if you were deliberating. Do not form or express an opinion about the issues in this case unless you are substituted for one of the deliberating jurors. Now, at this point, you have one of 2 options. One option is to come back here every morning at 9 o'clock and sit in the jury lounge till 4:30. Most alternate jurors don't select that option. The other option is you can go home and go about your business, and we will call you if we need one of the alternate jurors to be seated. As you've already seen with the one alternate juror, if someone needs to be seated on the panel, we will put your 3 names in a jar and pull 1 name out. So each of you have an equal shot at being on the jury should one of the deliberating jurors be unable to fulfill their obligations. So I imagine the 3 of you probably want to go about your business and be available by cell phone. Is that correct? I have 3 head nods. Okay, so, okay, right. Yeah, three of you all agree. So what will usually happen if we need to seat an alternate is someone will call in sick in the morning. I don't think anyone's going to get sick in the next hour, so you can all leave and go home, but please keep your cell phones on and make sure you answer the phone if you get a call from the court. Most likely would be in the morning somewhere around 8 to 10. And you just need to be available to come to the courthouse within an hour. Is that acceptable for all 3 of you? Yes, Your Honor. Okay. All right. So what we will do is we'll call you under one of 2 circumstances. If there's a verdict, we will call you and let you know what the verdict is. And if that's the case, you would then be released from the admonition, or you will receive a call instructing you to come back to court, and we will seat you on the jury. Now, if you are seated as a regular deliberating juror, the jury has to start their deliberations anew because your vote is just as important as any of their votes. So if a juror is unable to fulfill their obligation, we would seat one of you on the panel, and then they would begin their deliberations from the beginning. Because I said, your decision counts just as much as everybody else's. So with that said, do you have any questions? Anybody? No? What you can do is leave your notebook on your chair I know you have 2 notebooks because you filled one up already. Leave them on your chair. We will keep them safe, and they will be available for you if you need to come back and deliberate. So you can go home now and just wait for a phone call, and we will be in touch with you. All right?
Do we come back to court before the verdict, or we?
If you want, we can call you, and if we have time, if you have time to get here, you can. Do you want to? Would you like to be notified when the verdict comes in?
Yes.
All of you? All right, we will do that. Now, if you can't be here quickly, we won't wait for you because all the jurors will be right here, but we will certainly tell you, and you can jump in your car and head over here.
Do we sit here or there?
You would sit in your seat up in the jury box. All right, so I want to thank you for your service. If I don't see you again, have a nice day.
It's been a privilege, Your Honor.
All right, thank you. Five, 7, and 8. With respect to verdict form for count 5, you just wanted to change the language to sodomy by use of force or fear rather than sodomy by use of force, fear, or threats. Is that correct?
Correct, Your Honor.
And what's the reasoning behind that?
That's how it's pled, and that's how it reads in the statute, so it should be the same.
All right, and Mr. Owens, do you have any objection?
Your Honor, threats is included within the instruction. I'll just submit to the court.
Right, it is included in the instructions, so I'll leave count 5 as it is. Count 7 and 8 added the burden of proof for the statute of limitations allegation. You included the terms clearly and convincingly. Do you have any objection to that, Mr. Owens?
I do, Your Honor, because the burden of proof isn't reflected in any of the other verdict forms. I think it would be confusing to see it in that particular allegation, and it's adequately defined in the instruction.
All right, Mr. Watkins?
Yes, Your Honor, the reason why it's not in any of the other ones is because it's beyond a reasonable doubt, so because this is different, I think it should be placed in there.
I don't see any harm in leaving it in there. It's the only allegation that has a different standard of proof. So the court will adopt the instruction or the verdict forms the defense has submitted for counts 7 and 8. All right. These are the verdict forms that will go back to the jury. I'll give them to the clerk, and you can all have counsel review them before they go back there. But these are the ones that will go back. All right, Mr. Carlos and Mr. Watkins, if the jury requests readback, do you want to waive your client's presence for the readback if it's requested?
Let me discuss that with him really quick here.
All right? Yeah, those are them. And then we'll make an extra copy.
Would like to be here, Your Honor, for any readback or question
Okay.
for the jury.
All right, Mr. Winslow, if the jury requests readback of any witness, you do have the right to be present. A lot of times defendants just waive that right so that the court reporter can go back into the jury room. You don't have to. If you want to be present for readback, that's certainly your right. Would you like to be present?
I'll be present, Your Honor.
Okay, and then so Mr. Carlos and Mr. Watkins and Ms. Barr, you will also all be present?
Yes, Your Honor.
Yes?
Yes, we'll have lawyers here, Your Honor.
Okay. Well, it has to be one of you three since you're the
I said
lawyers
no.
of record.
We have 3 of us. We'll be here.
Okay, all right. And then Mr. Owens, do you want to be present as well?
I will be.
All right. Any other requests at this time?
Your Honor, just given the fact that the 3 of us are downtown, if there is, we'd like to, if there are questions, we can do that on the phone, I take it?
Yes.
Conference call?
Right, if there's a question, I'll come up with a response as I explain to the jury. Maria will call all counsel. Who are we gonna call on the defense side? I don't want her
call
having to
him,
call.
because he'll never get to us, so call either, actually call Ms. Barr. She's more
Okay.
responsible, she can get us online really quick.
All right, do we have your cell phone, Ms. Barr?
Yes, Maria does.
Yeah.
Okay, and well, I want all of your cell phones given to Maria, all right? And if there is a verdict, how soon can you be down to the courthouse?
Well, as I say, it's gonna take us 40 minutes to get here, at least,
Okay,
45 minutes, yeah.
all right, 45 minutes is acceptable.
as long as it's not like, get the fair happening, so.
Okay, all right. Are there any other requests then at this time?
There.
Yes, Your Honor. As to the exhibits, I was just noticing exhibit 88 and 86.
Right, those are the Strava application printouts.
I think those should be dated as to the dates that they occurred on. I thought the one that I had a little faint date on it, but these clearly do not.
It was dated through the use of one of the witnesses. Let me pull up my trial notes.
And Your Honor, the preceding exhibit for each one corresponds to the user account for that day.
Right, yeah, it's the overall map and then a close-up zoomed in portion, correct. Now, I did look that over and reviewed part of the transcript for that testimony. And it was established through Angela Rosa. So if you want to agree to put a date on it, you certainly can. Do you want to put a date on those? You want to handwrite one on there, Mr. Owens?
Because it doesn't seem like these are connected.
We can do that.
If there is no objection, then you can do it, because one is dated May 24th and one is dated May 23rd.
Yes, Your Honor.
So if you want to take a look at it, I'm sorry?
Then there's also one from May 10th. That's also.
All right, if you want to agree to write the dates on those, that's certainly fine.
I can do that.
All right, you can make those changes. And
Confirming that is as to number 88 and 86.
Correct. And what was the other one? I'll come with that.
all right, you can make the notes on it and you can notify the clerk which exhibit you're going to change. All right, are there any other requests at this time?
Not by their things, Your Honor.
All right, thank you very much. We are in recess.